My research examines the conundrum with the copyright protection of databases under Australian law. This necessitates examining how the current law of copyright subsistence is applicable to databases. What is particularly fascinating is that Australian copyright laws have their historical basis in English precedent drafted over 200 years ago. Also, there is the necessity to comply with minimum standards as outlined in various international treaties. In this fourth industrial era, incompatibilities emerge when applying ancient laws to new technologies, such as a relational database, which are created by teams of people. Databases are classified as literary works, and there is a requirement that they be an original work. Post-2009 precedent necessitates that this be a work of independent intellectual effort which is authored by a person. This is where a significant conundrum lies, because in some post-2009 Australian database cases, it has been impossible to determine that the database has been authored by a person. This has been due to the highly antecedent input by database producers. Such teams have issued instructions to computers, which have ultimately produced the databases. Several recent cases have found the work that people have performed in producing databases to be insufficient to constitute an original work of human authorship for copyright purposes. This has meant that copyright has failed, therefore leaving the database open to the parasitic behavior of competitors. Economically, these databases are worth a lot of money, with one Australian telco's database costing in excess of $1 billion to produce. What can be done about this conundrum? I have researched the database protection laws of the EU to see whether their laws might be useful to guide the future direction of Australian law. In 1996, they introduced a separate type of right to protect databases, which is known as a sui generis right. I have examined the application of this right using the UK as a case study. My research has found that although sui generis protection may sound promising to protect databases, the economic benefits have largely been unproven. I also examine the lessons that can be learned from the utilisation of open access initiatives. Taking into consideration the complex nuances of this topic, my thesis makes various recommendations which look towards solving these challenging issues. Thank you.